I do some consulting work on American
feeling in the room was
Don't ever say to her that
What about the Chaplains?
Introductory
discussion on the ethical
we left
more of a community.
We're China took back over.
Currently doing in autism.
In January, President Obama signed an executive order to close the detention center at Guantanamo Bay within the year. But legal experts say the new administration will face tough questions about what to do with the prisoners who remain and how to conduct U.S. detention policy in the future. We talked with Greg Mcneil, a visiting professor of law at Penn State's Dickinson School of Law. Mcneil is an expert on criminal law and procedure, counterterrorism, and national security law. He has advised Congress on these issues, consulted with the prosecution team in Guantanamo, and co-authored the first book on the trial of Saddam Hussein. In my conversation with him, we discussed the pros and cons of Obama's decision and the logistical and legal dilemmas of establishing a national security court. We also explore what impact the now infamous Bush interrogation memos will have on future protocol and how some of Obama's policies may not be as far from the Bush administration as many people might think. Greg Mcneil, welcome to the conversation.
It's good to be here. Thanks.
On his second full day in office, President Obama signed an executive order to close Guantanamo Bay within a year. That proves to be, or seems to be, the easy part of all of this. How difficult is closing Guantanamo Bay proving to be?
Right. You hit the nail on the head there. This is going to be a significant challenge for his administration. And it almost makes sense to think that, because if it were so easy to close Guantanamo, you would think that the Bush administration, even though they wanted to keep it open in the early phases, would have been able to close it once they started to realize what a political landmine keeping the facility open was. And the challenge really lies in two issues. The first is a detention issue, and the second is the trial issue. And they're distinct concepts that people should remain aware of. Figuring out who in Guantanamo should be tried for potential crimes, who should be detained because they're dangerous but perhaps not tried, and then who should be released, that is no longer detained, are the questions that the Obama administration needs to figure out.
Since Guantanamo Bay's inception in 2002, some 800 prisoners have made their way, have passed through Guantanamo Bay. How many are left? How many did President Obama inherit?
Right, he inherited approximately 225 to 240. The numbers that you hear from different locations are a little different. I think the 225 number is the most accurate. And within that population, you have a group who the Bush administration initially identified as subject to trial by military commissions. So that group numbered 80 at the most that the Bush administration ever said. Within those, it's really realistic to think that there's probably only 35 or 40 who would face trial, and that's a high number, who would face trial by either military commission or trial in federal court. So that's 80 of the 220 we spoke about. There's another group, sort of this indeterminate group of about 40, who the Bush administration knew was dangerous for some reason. The reason they would know that is either because another intelligence agency had some information, provided that information to the U.S. government and said, you can know this, but you can never use it and you can never disclose it. That's one type of information. We'll call that the most favorable information that the government has in its hands now. Then you have other information that might have been derived from waterboarding or coercive interrogation technique, either by the United States government or a foreign government, that says that this person is dangerous, identifies them as dangerous because of their relationship to a terrorist organization. And so those 40 people could never face trial in either a military commission or in a federal court, but you know they're dangerous and you just don't want to release them, but you need to hold them to prevent them from returning and attacking.
And so the question is, what do you do with them?
So that's the hardest.
Not to crack here.
Right, not to crack. That I was trying to find a better way to say it, but I think that's probably the best way to say it. And then, so we add that up, right? And then we have about 120 others who the Bush administration and the Obama administration have identified as subject to release, either because they're no longer a threat or because we don't think we need to detain them anymore, or know we're not going to try them. And so we're looking for a country who's willing to take them. And that is also a big problem that the president needs to figure out how to get allies to support us in taking these, sort of taking the problem off of our hands.
Before we even talk about what to do with the ones that we feel can be released, I want to talk about something that Dick Cheney said in an interview with Politico. He said that he called Guantanamo a necessary facility that, if closed, would put Americans in danger because those who are released would return to their terrorist activities. That compared with the journalist and terror analyst Peter Bergen, who's argued that most of the detainees at Guantanamo have never posed any real risk to America for the simple reason that the vast majority of them were never enemy combatants in the first place. What's your reaction to the two statements?
The Bergen number, that might have been accurate maybe a few years ago, but what we've whittled the population down to now it's a fair statement. It's an accurate statement to say that there are probably about 80 detainees who are in fact dangerous and you wouldn't want to release them. And then there is a group that could be released. But even if you release them saying you think they're no longer a threat, there's still a chance, right? And so what there's no certainty in this. And so what the president is faced with is the chance that some of the people you identify for release might return to the battlefield and fight against the U.S. on a battlefield, or might come to the U.S. shore and fight against the United States.
And in fact, the Pentagon already says that 61 of the detainees that were released during the Bush administration are engaged again in terrorist activity. 18 have been confirmed, 43 are still considered suspects.
Right, so even if we take the low number of 18, which 18 out of 800, I'm not a math guy, I'm just a lawyer, but let's say that's 5% or less, 2.5%. If 2.5% of the 100 that you release end up deciding to fight back against America, it's about 2 people. But if one of those 2 people detonates a car bomb outside of an American base and kills 75 American soldiers, or comes to the United States and commits an attack, you can rest assured the political consequences of that would be significant. And so the administration is weighing that concern. There's the potential that even those we say are not a threat might turn back and fight against the United States.
The U.S. military has leased Guantanamo for 100 years. It was closed in 1993. There were Haitians with AIDS who were held there by the first President Bush and released by President Clinton. Talk a little bit about the history of this notorious place before we talk about whether and how to close it.
Sure. So the Guantanamo naval base has been there. It's a legacy of the Cold War. Its initial purpose was never to detain individuals. But in 1993, as you noted, the president made a determination there when Haitian immigrants were trying to come to the United States to house these individuals at Guantanamo Bay in rather makeshift camps. And so the Bush administration lawyers, when trying to make a decision about where to detain individuals, had some court precedents that said individuals detained at Guantanamo are not within the United States. They don't have the right to sue for habeas, and therefore they saw this as what many refer to as a legal black hole, or at least they thought that this was a place where individuals would not have standing to sue the U.S. government.
The U.S. Constitution doesn't apply here.
That was right. So that was the understanding at the time that the 2001 policies with regard to the detention facility were crafted. And so they really believed that by placing these individuals there, they would be beyond the reach of the law. Now, a more charitable way to look at that is to say, we're engaged in warfare. This would be the Bush administration position. We're engaged in warfare. Individuals detained in warfare have never had the right to sue for their release. We detained hundreds of thousands of German soldiers within the United States during World War II. They never had a chance to go to court and say, I shouldn't be detained, and therefore that right should not extend to individuals who don't wear uniforms, don't follow the laws of war. And so that's the law of war analysis that the Bush administration engaged in with regard to detention. just the detention issue.
Although the U.S. Supreme Court has ruled 3 times that these detainees do have the right of habeas corpus. They do have a right to challenge their detention.
That's right. And so the most recent decision was just this past summer, which said that that habeas corpus rights extend to the detainees held in Guantanamo. What that means is that the notion of habeas corpus is you go into court and you say, I want the individual who holds me or detains me, holds my body, the corpus, must give a basis for why I'm being held, I'm challenging that, and I want to be released. Now, this overruled essentially an earlier Supreme Court precedent from 2002, the Hamdi opinion, that said, yes, these individuals can be detained, and Hamdi was a U.S. citizen, can be detained as enemy combatants, but you have to provide them a neutral tribunal in which to challenge their detention, but that neutral tribunal could be a panel of U.S. officers. You have to give them the evidence against them, but there could be a burden in favor, the burden could go in favor of the government's evidence. You could admit hearsay. So from 2002 until the decision this summer, the Boumediene decision, that's how the courts were operating. And of course, all of that was challenged. It was challenged in the D.C. District Court and the D.C. Circuit Courts, saying, listen, this process that was established by the Department of Defense is inadequate. It's fraught with errors. Sure, you're providing us the evidence, but you're not providing all of the evidence, the exculpatory evidence, that evidence that might suggest that I'm not properly detained. And so the detainees ultimately prevailed on that position.
Well, there are many who say if we close Guantanamo Bay, all we're doing is moving the problem, that the need to capture and detain terrorist suspects will remain. So I want to ask you kind of a basic personal opinion. Is closing Guantanamo Bay the right thing to do?
Tough question, right? And I'm not dodging here, but I think for a policy decision, Guantanamo is sui generis. The policymakers should look at Guantanamo and figure out how to solve the problems that relate specifically to those remaining 200 Guantanamo detainees. But in crafting a policy for the future detainee who has yet to be picked up on the battlefield or elsewhere, Guantanamo should not be the way that we look at it. Because Guantanamo, the laws that brought us into Guantanamo, the laws that created the circumstances, the mess of Guantanamo, have changed since the point of those individuals being captured, detained, and perhaps even ultimately tried. And so trying to fix the Guantanamo solution, in doing that, we shouldn't go breaking or crafting poor policies for the future, I guess is the better way to say that.
I want to find out how you think we ought to craft this new system, but before we do, I want to talk about, of those 220 detainees, the ones where the federal government has said, you're not a risk, you're free, but we have no place to send you. You can transfer them abroad. They can be relocated in the United States.
Right, and so there really are three. One being find a country who's willing to take them, transfer them abroad. The other, release them in the United States. I guess the third option, status quo, do nothing, right? And perhaps even a fourth, transfer them to other countries without getting that country's consent. I call this the status quo ante option, where there was a recent opinion in the D.C. Circuit that said that sort of a reverse rendition. It said that the Obama administration does not need to notify the lawyers for the detainees who are held in Guantanamo that they are transferring them to another country. They don't need to provide notice to them. They can just do it. Now, this is very unilateral, not in line with President Obama's mentality, but my reading of that suggests that there's nothing to prevent the Obama administration from loading those detainees they want to release onto an airplane and transferring them back to the exact same location that they found them at, and saying, you're released. Now, obviously, there's a way to do that would be nicer to them, perhaps providing them money and food and a place to live and whatnot. And there's a risk with that you anger the country that you transfer them back to. Most of these detainees were picked up in Afghanistan or Pakistan, two allies in the region that you don't want to make upset. But certainly doing that wouldn't require spending any political capital and could potentially solve that problem. So there's possibly four options. That one runs a lot of political risks. The transfer with the assent of foreign countries runs into the problem that no foreign country wants to take these individuals because we ourselves are saying, they're too dangerous for us to release into our country, but feel free to release them into your country. Or what's going on behind the scenes is you have a country, Albania, let's say, that says, sure, we'll take them, but it's going to cost you.
Many of the detainees who have been released to date have gone to Saudi Arabia and to Afghanistan. And as you said, there are a number of other countries who are considering doing it, a number in Europe, Spain, and some other countries. Talk a little bit about what it would take and what kinds of agreements are involved?
Sure. Another group is the Yemeni government. In fact, the largest group of detainees still remaining in Guantanamo who we've identified for potential release are from Yemen. The problem with the Yemeni government, for example, is that as we've released individuals there within 6 months, they've escaped from the Yemeni jails, or they've been helped to escape, or the jail door was just opened and they left. And so now we have the number 2, or perhaps the number 1. I never know who has what number.
You don't have your trading cards?
But generally, for a while, you didn't want to be the number 1, like Al-Qaeda in Iraq person, because there was a missile headed your way. And so when it became time to be number 2, everybody sort of pointed this way, you take the job. But in all seriousness, one of the key leaders of Al-Qaeda in Iraq is in fact a released Guantanamo detainee. And so the U.S. position is not only do we want to release these people, but hey, we need some serious security assurances from you that you'll ensure that this person is continuing to be detained, but you also won't mistreat them and that you'll give them a fair trial. And so we want you to respect their human rights in a way that's consistent with your own country's laws, but we also don't want you to be so nice to them that you allow them to leave. And so we're trying to dictate to these countries what policies they'll put into place and how they'll handle these detainees. And when you start to dictate to foreign countries say, sounds like you're in a real pickle here. What do we get in return? What kind of foreign aid can we get in return? How will you vote on this treaty that we're interested in? And so very important and difficult issues for the government to resolve.
And we're talking about detainees who, the ones remaining at least, represent 30 different countries.
That's right. And so, so you have potential agreements with not only the countries where the detainees are from, so their country of citizenship, but then perhaps other countries who might be willing to take the detainees.
Well, another problem that arises is some of the detainees who have been sent back to France, for example, the information that we gathered from them and that we used to detain them is information that would not be admissible in a French court.
That's right. And so, and in fact, the information that we use to detain them might not be admissible in a U.S. court. And so the standards for detention are much lower than the standards for convicting someone in a court. It's not beyond a reasonable doubt. It's like pretty much a preponderance of the evidence standard, or perhaps even lower. And that's consistent with the laws of war. If we went to war tomorrow with the Iranians and we captured uniformed soldiers from the Iranians, all that the Geneva Conventions require is that if there's any doubt as to whether or not the person should be detained, a panel of 3 military officers will review whether or not they should detain that individual and make a determination. No court will weigh in on that judgment, the judgment of the military on the battlefield. The challenge we face is that terrorists don't follow the laws of war. They don't wear uniforms. They blend in with the civilian population. So what that presents is not only it gives them an operational or tactical advantage because they can blend in with the civilian population, but it also presents the possibility that you might wrongfully detain the innocent civilian aid worker, which is the big argument or the person who's on Hajj. That's the 2 big arguments that many of the Guantanamo detainees make. So there's a greater potential for error in these types of detention situations. But then the flip side of that is if you wrongfully release the person who should have been detained, there's a great chance that person will come back to harm you or your country's interests.
You mentioned aid workers, and I'm thinking of the International Committee of the Red Cross, which is the only organization that has been allowed inside, except for military personnel, into Guantanamo Bay. We've all recently been reading about information that's been leaked about torture. 14 detainees who have corroborated information about some pretty explicit acts of brutal torture. But I want to talk about because the Red Cross's agreement is that they will they have access to these places because they'll only report back to the institution or the military holding them, or the how important is it that that information was leaked? And does it jeopardize their ability to do this in the future? It
does. Any leak of information that is in confidence between nation states or between organizations like the ICRC and a nation state runs the risk that it sets a precedent that in the future we're not sure that we can trust your assurances that that this will remain confidential. And so the ICRC, as you mentioned, has a very unique status in international law. The Geneva Conventions actually state that the ICRC has a role in detainee treatment. And so what's developed over time is that the ICRC has, within every country, they have their own liaison groups to each nation. And the ICRC in that role has the legal right to go visit detainees and then report back only to the nation state that's holding those detainees and let them know where there might be violations of the laws of war. And this is a very brief summary of their role and responsibilities. That only comes, though, with the assurances that it will be confidential. The ICRC is so confidential that even if someone were to release, let's say I worked for the ICRC and I decided that I was going to steal all the confidential memos and release them and publish them on my personal website, the ICRC is so confidential that they would not even sue me in court to try and get those documents back because they don't want to subject themselves to the discovery process. That's how closely they guard their communications between nation states. And so the release of those documents, and who knows how it happened, either someone within the ICRC with malicious intentions, someone in the Bush or Obama administration who decided that they were going to release this information. Those are the only two sources where this could have been released. That's done some harm. I mean, everyone, I think, takes the ICRC at their word that they won't release the documents, and they take good faith efforts not to release them on their end. But you'd never know. This sort of thing sets a precedent that in the future a government might say, I'm not sure that I can trust that you're not going to release this information. Very top secret, sort of classified information. So why should I give you access?
So access may be denied.
That's right. And so why should I give you access to these detainees?
Well, speaking of leaked information, of course, we're also reading about CIA memos that authorized certain treatment. What's at stake there? Okay, so you have a similar, there's a lot at stake, and there's a few issues embedded in there. The first issue is the potential risk that the CIA will be deterred from fully and faithfully executing their job in the future. They might phone it in, so to speak, or pull back a little bit, saying, I'm not sure what's going to happen in the future. That's one. There's also a risk with our allies abroad. Our allies abroad might say, I'm not sharing any intelligence information with you because I don't know that I can trust you to not release this information or the next president to release this information. It's a second risk. A third risk is that you communicate the policies, the maximum boundaries of how far the U.S. government's willing to go in interrogations. If you put the line down, the enemy can then train for that. And there's some other consequences too. Perhaps the fourth is that you incite people. When you say train for that, people might train to be able to withstand waterboarding, for example? Sure. For example, if you read the CIA memos, the OLC said that there's a maximum of, I think, 41 seconds that an individual could be waterboarded for. Rest assured that if Al-Qaeda is reading that, they're going to start training their people on 41 seconds of waterboarding. This is how you have to, how far you can go. Also, they'll tell their members, their operatives, that listen, if you're placed inside a box and they tell you that they're putting a poisonous insect in the box with you, it's not poisonous. It's actually not poisonous. Don't worry about it. So you can start to glean from this information about how to prepare for the interrogation techniques that might go on. Moreover, the entire goal of the interrogation techniques was to disorient the detainee and make them think that the government was going to go further than they might. And now they know. Now the enemy knows exactly where the lines are drawn. In fact, the OLC memos reveal to us the line that was drawn, that the Obama administration won't even go that far. So they know that if they train to that, they're training to the maximum that's already been taken off the table. And so
those are some of the risks associated with releasing the memos. I'm sure as we talk, I can think of a few more.
I want to get back for a minute to these leaked memos and the impact it's had on some very important relationships. I'm talking about the relationship between the United States and the UK, for example. There apparently was information about a particular detainee who the British government has information to corroborate that they were tortured, and there's been fighting between there was fighting between the Bush administration and the British administration about what they would release. Talk about what impact the war on terror has had on this very important relationship.
Sure. One of the precepts of the war on terror is that intelligence cooperation is critical. And so while we might have some information about, it's the connecting the dots sort of analogy. And so while we may have some information about an individual, it's key sometimes, some of the key information we might need will also come from foreign governments who have their own police force, their own intelligence agencies, perhaps even human intelligence, individuals within these terrorist networks. And so it's absolutely critical that we have cooperation between governments. And so now what's also at stake there is that if a nation state wants to cooperate with us, they need real assurances that that information will not be released. That could be that the information itself won't be released, or that the sources or methods by which the information was arrived at won't be released. Because there's a theory called the Mosaic Theory, that if you release, let's say, just the information itself without how you got it or how it was put together, someone observing that, taking that one seemingly innocuous piece of information, could put the picture together and, like a mosaic, understand what the broader picture is.
You've worked with both countries to establish good counterterrorism tactics. Tell me, where are we? What's needed?
Sure. So the healthiest alliance is really the relationship, the transatlantic relationship between the United States and the UK. Also, our relationship with Canada. So those are very strong relationships. There is some criticism that the intelligence sharing relationship with other countries, it doesn't go far enough. That it's sort of one way. That the United States is happy to accept all the information they can from a foreign government, but isn't necessarily willing to release or send the information back to that foreign government. The intelligence sharing relationship also becomes more complicated because the European Union has very stringent rules about what types of lists you can keep about individuals, what type of personal information you can have about them, and who you can share that information with. And so with the U.S., when we try to establish relationships or agreements with them for, let's say, a watch list, we run into the problem that we're not just bound by U.S. law, but in our agreements with them, we have to be sensitive to their own laws with regard to watch lists and information, personal information that's collected and stored about individuals.
There are apparently terror watch lists with more than 1 million names, 1 million names on them. Tell us a little about these lists, how you get on them, how you get off them, and legally speaking, what are the implications of these lists?
Sure. This is something of a perilous merger, we could call it, between standards that we pull from the criminal law, criminal procedure paradigm and import into an intelligence paradigm. And so let's say that the watch list we put into the intelligence paradigm or the intelligence box. What happened when they developed these these terrorist watch lists was the U.S. government determined that if you were going to be placed on that intelligence watch list, all that was necessary to put you on that watch list was that there be probable cause to believe that you are affiliated with or are in fact a terrorist. That sounds pretty good at first blush because you think, hey, those are the standards we use in federal court. If it's good enough for our criminal procedure and meets the Fourth Amendment's requirements, then it really should be good enough to put an individual on the list. But it's selective. It cherry picks the information. What it does is it says, we'll have this low standard of probable cause to put you on the list, but unlike a court proceeding, after you're on the list, there's no ex post review of that. And so in the criminal law, if I have probable cause to believe that you're a criminal, I can arrest you. I can either go to a judge and get a warrant to arrest you, or if I'm operating subject to some exception to the warrant requirement, I can arrest you based on probable cause. But then I have to go before a judge and prove that I have the probable cause to continue to hold you. And then to continue to hold you beyond a certain period of time, I have to charge you and put you on trial and meet a burden of proof of beyond a reasonable doubt. So in the watch list, it's probable cause to put you on, but there's no subsequent review procedure, or the subsequent review procedures that are in place put all of the incentives on not ever taking someone off the list. It's like Hotel California. You can check out any time you like, but you can never leave. So you can try and challenge your status on this list, but the review procedure that's put in place puts the incentive on the intelligence officer, or even the local law enforcement officer in some states that can put you on this list. It says, do you want to be the person who takes this person off the list and says they're not a terrorist? And in fact, the burden of proof is to affirmatively overrule the determination of the other person who put you on the list. And so there's big incentives to err on the side of caution and put someone on the list, and also err on the side of caution and never take them off. It's very potentially dangerous.
Is it possible to know if you're on the list like you could with a credit check, for example?
Well, when you show up at the airport, you'll know, because if you're on the list, you'll be flagged for secondary screening, and it's possible that you won't be able to continue on your way. There's some legislation that's been put in place to try and clear up these watch lists, and you can also file a request with the Department of Homeland Security to ask if I'm on the list. But the backlogs on these lists are pretty long. So there's a lot of challenges, but it's the most striking thing about this is that it's easily solved. All it requires, there's congressmen who say, listen, there's nothing we can do about this except for maybe more oversight. That's not true. These congressmen could get together, pass a piece of legislation that says, sure, it's probable cause to put you on the list, but then it's required that there's a secondary administrative review process, just like we do with any other administrative regulation that's passed, where you can go before a panel. You can say, I shouldn't be on this list. Here's the evidence that I'm a former assistant attorney general. I'm not a terrorist.
Critics have said that the arrangements that were put in place and the legal and political risks that were taken by the Bush administration have obviously complicated and made this situation very difficult for Obama. But there are people now saying, well, Obama wants to close Guantanamo Bay, then in a lot of ways he's not as far off in thinking as Bush was. And I think people will be very surprised about that. So where do their beliefs about all of this converge?
Sure. And so there's a few different places where the Obama administration seems to have adopted the Bush administration's policies. They are lockstep in line with the Bush administration for asserting the state secrets privilege. That is when a citizen brings the government into court for a civil suit, the federal government can say, we're not going to release this information because it will expose state secrets. The NSA wiretapping program, also which falls under the Foreign Intelligence Surveillance Act. Senator Obama did not vote against that. He has that authority under the new FISA statute to engage in warrantless wiretapping if it's related to foreign intelligence or counterterrorism purposes. In court, the Obama administration advocated that they were no longer using the term enemy combatant to describe those individuals who were held in Guantanamo.
What are they going to call them instead?
And it's not clear what the term that they've chosen to adopt instead is, but less than just the enemy combatant language is that they slightly modified the detention rationale for those held in Guantanamo. So where the Bush administration was looking for some connection or ties to a terrorist organization, which the Bush administration actually argued in federal court, they argued that definition read broadly could also include the grandmother who unknowingly donates money to a terrorist organization. Pretty broad and expansive argument they made in court that they backed away from after making that argument. The Obama administration has adopted much of that, but to protect against the grandmother wrongfully swept up, or someone whose contact with a terrorist organization is so attenuated that it makes you wonder if they're really tied. they added this new language, substantial ties to a terrorist organization, which doesn't change the situation for any of the people who are now currently held in Guantanamo. So those are the areas of potential commonality with some slight differences. The big differences are the release of the CIA interrogation memos, that information, the change in the coercive interrogation processes that the Obama administration is willing to support, and then what they're going to do with Guantanamo is a big potential change, because it leaves open the question of how are they going to handle individuals who are detained who are believed to be threats.
And in fact, you have consulted with the Guantanamo prosecution team on this, and there are a number of different options: a military commission, a military court-martial, a federal civilian court, which we've used before, and this national security court, which you've talked a little bit about. Briefly tell us about those, and which do you think is going to play the most important part in trying those who can be tried?
So as a threshold issue, what we have to recognize is no one's going to be happy. Whenever President Obama makes his decision, he's either going to anger the right more than he already has. He's going to anger the left for not going to the fullest extent of what their position is, which is really release everyone or try them in a federal court. And he'll probably anger the center, who some want to feel safe, but also think that there needs to be some solution that will make everyone happy. There's no solution that will make everyone happy, and that hasn't even brought in international allies or foreign countries who have their own opinions.
He's
on this
between
as
a
well.
rock and a hard place.
Oh, that's exactly right. And so the four categories that you mentioned, federal court, yes, it's been successful before. The 93 World Trade Center bombers were tried in federal court. We mentioned earlier the problems with disclosure in federal court that could come up with them. That was a specific example of a challenge that they'll face.
And the people who were convicted in the 1993 World Trade Center, they're in federal prison.
That's right.
Which, of course, has some politicians worried that they could be working with gangs in prison,
That's right.
that they could really change the whole chemistry of prison.
That's right. They could radicalize the gang population. There's a series of reports out about that as a concern. But more than just that, the distinction between the 93 World Trade Center bombers and those detained in Guantanamo, the 93 World Trade Center bombers were surveilled within the United States by the FBI. A case was built against them, and they were arrested within the United States with evidence that was built in a normal criminal process. So let's fast forward to the most recent federal cases: the trial of Zacarias Moussaoui in the Eastern District of Virginia, the trial of Jose Padilla, and the charging and trial, or almost trial, of John Walker Lynn. The American Taliban was the name given to him by the media. John Walker Lynn was a plea agreement, 20 years. Zacarias Moussaoui also a plea agreement.
The architect of 9/11.
Right, and Jose Padilla was a conviction. And so what we have in each of these cases, though, especially the Moussaoui case, is that Zacarias Moussaoui pled out, so it's held up as an example of how federal courts are adequate. But had he not decided to sign a plea deal and plead guilty to his offenses, what we would have faced was the potential that the U.S. government was going to have to give him access to Khalid Sheikh Mohammed as a witness as a witness who would testify that Moussaoui was not actually responsible for engaging in the attack plot that he was initially arrested for. And so there are some limitations with federal court, but it's been proven successful in some cases, and it's certainly the most legitimate of all the options. Depending on how you measure legitimacy, it's a tough call. It's pretty subjective. Then there's courts-martial, very similar issues that you would have in an Article III court. Then existing military commissions. Lots of critiques of the existing military commissions, that they create ex post facto law, that they allow hearsay testimony in, that the laws that they're seeking to charge individuals with, this is the ex post facto law issue, don't exist either in military law or in international law or in federal criminal law. They're made up offenses is essentially their critique. And then a national security court is this proposed option that's being kicked around, but nobody knows if the national security court options are being kicked around as a detention-only option, not adjudicating guilt or innocence, or one that will actually make that adjudication and then some combination of the two. So there's a lot of options, but there's also a lot of indeterminacy about how exactly those options will play out for the Guantanamo detainees.
I'd like you to tell us how a national security court, this hybrid court that you're talking about, how it should be created, what influence the international community would have in it, and this idea that you have that these new institutions should be created top down rather than the other way around.
Right, rather than bottom up. And so to make the top down and bottom up analogy clear, I would say top down is take the existing Article 3 court and figure out what won't work with it. Take federal courts, and if you say, remember we talked about Rule 16, Federal Rule of Criminal Procedure 16, that requires disclosure of the unindicted co-conspirators. If that's a problem, then amend that rule for specific terrorism offenses so that that's not required. If you're proposing a national security court, then why not amend some of the rules of evidence that will allow information from battlefield circumstances to not have to go through the chain of custody issues that you would normally expect in a federal court. Rather than starting from scratch, cherry picking the things that you think are most convenient in creating a court. That's what we saw with the military commissions when President Bush created them by executive order. They were then ruled invalid in 2006 in the Hamdan opinion, and then the president proposed a new set of legislation that was ramrodded through the Republican Congress prior to the election with many potential defects that were known to everyone at the time, and now we're in a position where all of those procedures are subject to challenge, and some of them have been overruled subsequently by the Supreme Court. And so why start from the bare bones position? My argument is start with Article 3 courts and then tailor them appropriately. Now there's some challenges with that too, because it's unclear now, but it's a significant possibility that if you move the Guantanamo detainees into federal court, they get the full panoply of constitutional protections. That means statements that they made that were not Mirandized don't come into court.
But you can change that if you create this national security court. You can say that doesn't apply.
No, and that's the challenge, and that's the most difficult part that for the average person to realize is that if a court decides, or the Supreme Court decides, that the detainees are entitled to constitutional rights, which if you try them in a federal court will be the case, then they get all the rights. There's no picking and choosing, and constitutional rights can't be changed if it's a substantive constitutional right. It cannot be changed by the Supreme Court. That means that the right against compelled self-incrimination is in. That means Miranda, which the Supreme Court has said is a constitutional requirement. They said in their Dickerson opinion. That means all of the protections of Miranda come in. Any statements while someone is in detention.
Is this retroactive?
That's right. And so it would apply to those individuals. If you seek to admit Khalid Sheikh Mohammed's statement while he was detained and you didn't Mirandize him, that statement's in. And even if you did Mirandize him, there's an argument that, and he waived his Miranda rights, there's an argument he could make that, listen, it's not a valid waiver because when I'm detained incommunicado for 7 years, it's coerced and it has to be a voluntary waiver. And that's just the Miranda issues before we even get to the speedy trial issues.
Well, President Obama put all of these prosecutions on hold for at least 6 months while Eric Holder and others kind of think about where to go or how to proceed from here. And so I'm wondering, how many of those remaining detainees do you think will actually get a trial? And with what representation? Who is going to represent them? And who's going to pay for their representation?
Sure. So I think if I had to make a taxonomy of the detainees, the 120 we said would be who are able to be released. Let's just assume for this discussion that we find a way to release them, or we do my ex ante position and just take them and release them back where they were found. Let's just say that we've solved that problem, right? Snap our fingers and it's all done. So now we're left with 35 or 40 that we say are dangerous but nowhere to try them. We'll deal with those in a second. I think the administration will probably identify about 35 or 40 that they can try in federal court. give you a few examples. There's a detainee named Omar Khadr who's held in Guantanamo. He's alleged to be a child soldier, so that really puts the international human rights community up in arms.
He was 14 when he was picked up.
15 when he was picked up. 15 in 10 months or something like that. And so if you try him in federal court, though, you don't run into any obstacles because we frequently try individuals in federal court who happen to be juveniles, and we charge them and try them as adults. And so you make an end run around some of the international law arguments there. And he's also an easier case to try in federal court because there's video of Khadr putting together improvised explosive devices. I think you can find the video on the internet. I hope I'm not revealing some secret information here. And so that's pretty straightforward. You can offer that evidence, you can put it into court, and anything that happened after that video, you just wouldn't seek to offer that information. So if he made a coerced statement, why offer that information? You're going to open the door to it being excluded. If you can try him and convict him on that, he's okay. If you can try and convict Khalid Sheikh Mohammed on information that existed prior to his capture and his waterboarding. And so those are the easy cases. You figure out what evidence you can use that's not tainted and offer that in federal court. The problem is that other group, right, of 35 to 40 who are dangerous, but you don't know what to do with them. You might be able to try those individuals in a military commission. And so President Obama is going to be left making the decision of, do I keep the military commissions as they are, or do I recraft the military commissions, call them military commissions 3.0, the first being the Bush executive order ones, the second being the ones we have now, and now the third being whatever President Obama decides to do. That's a possible option for him, and from what I understand, the review team is actually very interested in what rules are in place in the military commissions, and that's an option that clearly it seems like they're considering.
But I want to know who defends them and who pays for it.
Right.
And the reason I want to know that, though, is you were involved in Saddam Hussein's trial, and we know that judges were killed, defense attorneys were killed. How dangerous is it for someone to defend Guantanamo Bay detainees, and who's footing the bill?
And so the example of the Saddam trial is a good one. I was on a team of scholars, legal experts who have some expertise in international criminal law, who were providing legal research support and advice to the U.S. government's Regime Crimes Liaison Office that then advised the Iraqi High Tribunal. And so we drafted legal memorandum and helped the RCLO figure out how to advise the Iraqi government. And what we saw in the Saddam trial case was that there were tons of attorneys who were happy and willing to defend Saddam Hussein. I don't think we're going to have a problem for the detainees of them finding representation. If we try them in federal court, they'll be entitled to a lawyer if they can't afford one. So the Federal Public Defender Service will defend them. And so what we're also seeing, though, there are hundreds of law firms and hundreds, perhaps even thousands of lawyers who are willing to sign on to either defend a detainee or to provide habeas representation for the detainees. So I don't think they'll have a problem finding pro bono legal support, but if we, legal representation. But if we do decide to try them in federal court, they'll also be entitled to a public defender, just like the person who's a mass murderer, just like the person who holds up a liquor store. Those are the types of rights that we pay for as citizens. We foot the bill for that type of defense, and I don't think there's anything wrong with that.
Those who are released, and many have already been released, what do we owe them, especially those who really got caught up in the net and they were really in the wrong place at the wrong time?
Right, good question. Right now it doesn't seem that we're willing to say that we owe many of them anything. There is one case where an individual was wrongfully picked up and tortured by the U.S. government, and I think that he had a settlement of in the millions of dollars that was entered into him with him as sort of an apology for wrongful detention. But let's set aside that any wrongful detention and torture. Let's set aside that if an individual was tortured, because not all of the individuals were tortured or abused in Guantanamo. And so of that population of 120. So let's say we release those individuals. What do we owe them, right? Coming back to your question. Let's say we do my ex ante option where we put them back where we initially found them, right? Put them back into the circumstances they were in prior to their capture. What do we owe those individuals? Well,
We've had 6 or 7 years of their lives.
Right. There's one argument that says we owe them just as much as we owe the wrongfully convicted person that you release from jail. So if you're in Virginia, you're wrongfully convicted of a rape charge, you serve 10 years of a sentence only to find that DNA evidence exonerates you and someone else is responsible for the crime you were convicted of. When you walk out of jail in Virginia, they hand you a manila envelope, and in the envelope is your keys and your ID that's 10 years old now and out of date, and the clothes that you walked in on. And we as a society say we don't really owe you that much. Now it's different in some states. There's some opportunities to create a fund for those individuals. So under that line of thinking, we say we're sorry and we don't owe you much. That, I think, justifiably bothers a lot of people, just as it bothers a lot of people when we wrongfully convict someone. But that's not to say that there's not an opportunity to create a mechanism to provide people monetary support, or to provide them a home in the country that they're headed to, or to give them an opportunity to sue in court to get that sort of remuneration for what's happened to them. So there's possible solutions there. And if we decide to release these individuals, I think that's something that we probably should consider. Considering it is our obligation. Whether or not we do it as a nation is really the political decision.
So we closed Guantanamo Bay, but there are other U.S. detention facilities in other countries. There's a primary one at an air base in Afghanistan.
Right,
so what happens there?
Right. So, well, the D.C. Circuit just recently said that habeas rights extend to the Bagram Air Base in Afghanistan. So while the Supreme Court's Boumediene decision that extended habeas rights to Guantanamo said that this decision is limited to Guantanamo, a judge just recently ruled that actually that decision also should extend habeas rights to the Bagram Air Base, which is an active combat zone. But the opinion was limited in some respects to say, but we're only looking at individuals who have been held for 6 or 7 years and were not picked up in the theater of battle. To give you an idea of how this is handled differently in Iraq now we're at the point where when our infantry soldiers go out on a mission and decide that they're going to go to a house where they think that an alleged terrorist is, they will kick in the door, go in just like you would expect an infantry unit to do, with flashbang grenades and firing real bullets, not a police procedure in many circumstances. But prior to doing that, they need a warrant from an Iraqi judge. And prior to returning from that objective, they need to collect evidence, bag evidence, and bring it back to a lawyer in the rear. Now, it's an open question whether or not you think that's a good thing or a bad thing that our soldiers are doing that. And that is largely an outgrowth of the requirements of the Iraqi Central Criminal Court, which handles these detainees, and also an outgrowth of our Status of Forces Agreement. But we're potentially heading towards the judicialization of the battlefield, not just for the detention purposes, once the person's held and how we treat them, but also for purposes of how the actual capture is conducted. I don't know, that's a normative question, whether or not that's a good thing. That's for us to debate, but it's something that we have to recognize, that when we allow the courts into parts of detention issues, that can potentially extend all the way to the point of capture decisions, and it's a possibility.
The Bush administration has defended its counterterrorism policies and its controversial interrogation techniques by saying that no attack has happened on U.S. soil since 9/11. Therefore, the policies were successful. And I'm wondering if it would also be fair to say, though, that we have lost a lot of international goodwill as a result of those policies, which put us at risk.
Sure. Certainly, the international goodwill issue. If you're concerned about the opinion of the world, that the opinion that the world holds of the United States, if you're concerned about that, then the change from the Bush administration to the Obama administration certainly suggests that President Obama is far more popular amongst the world's population. But it's not so clear that popularity has translated into policy success. For example, on his most recent trip to Europe, he asked that the Europeans commit more troops to Afghanistan, and he was rebuked. There was no offer of committing any additional troops to Afghanistan. So it's not clear that being popular necessarily translates into policy success. On the point, though, that the administration makes about the fact that there was no attack and therefore that proves that we are safer, yes, there was no attack and they deserve credit for that, but I don't know that the techniques necessarily were what made us safer. I drove here today, I had a cup of coffee this morning, and I didn't get in a car accident. That doesn't mean drinking cups of coffee in the morning will prevent car accidents. Now, the flip side of that argument, though, is it's less of a civil libertarian argument. It's just sort of an efficiency argument. If you detain all of the 220 people who are held in Guantanamo, there's 100% certainty that none of those individuals will return to attack you. Just like if you decide to execute all shoplifters, they won't shoplift again, right? Now, the problem with that, though, is there's always the potential for error. The difference between the administrations is that the Bush administration erred more greatly on the side of caution and was less concerned with public opinion, either internationally or domestically. The Obama administration sees that public opinion as part and parcel of the ability to achieve policy successes, and therefore they err more on the side of being concerned with that, with policy successes that can be achieved through public sort of public goodwill. Time will tell which is the right decision, but the Bush administration definitely had the 100% certainty thing on their side.
Although even detainees who have been released under President Bush have gone on to become suicide bombers, so there's risk here.
Right, that's right.
Really
So,
a lot of risk.
So the Bush administration, even under their strict policies, made mistakes on the side of individuals potentially coming back to attack the United States or kill Americans. I
want to end with this. Just how optimistic are you that we will get this right? There is so much to do, and what's at stake? I'm only optimistic if the president is able to engage the Congress. Because the problems we had from almost from day one up until the end of the Bush administration were largely an outgrowth of congressional acquiescence. Congress sat back, let the president take the initiative, and then it was a battle between the president and the courts. And Congress sat on the sideline and only acted when the courts had something to say. When policy is developed in that fashion, it necessarily places much of the judgment and the burden in the hands of the courts. The courts are not a representative body. The courts are not accountable if they make the wrong call and an individual is wrongfully detained, or they make the wrong call and individuals are released and then come back to attack American citizens. There's no accountability there. You can't vote them out of office. They have life tenure. And so the only way I'm going to be optimistic or hopeful is if the president can successfully engage Congress in crafting a durable, long-term policy. But what's clear right now is Congress is shrugging its shoulders and saying, well, we're not sure what to do either because we're trying to please everyone. And that's really the difficult situation that we as a country are in and that the president's in right now. I guess we're going to see this unfold. Greg Mcneil, thank you so much for talking with us.
Thanks. It was great being with you.
Thank you for joining us for our conversation with Greg Mcneil, a visiting professor of law at Penn State's Dickinson School of Law. For more of Mcneil's thoughts on the latest developments at Guantanamo, you can check out his blog. You'll find a link to it on our website at conversations.psu.edu. We hope you'll be sure to join us for our next conversation.
Production funding provided in part by the Corporation for Public Broadcasting and by viewers like you. Thank you. This has been a production of WPSU. A copy of the program you've just seen can be purchased through Penn State Media Sales at mediasales.psu.edu or by calling 800-770-2111.